wait as people join, okay?
Okay. Great. Thanks, Fraser. So hi, everyone. My name is Claudia. I'm a lawyer at Eiler Campbell. I have a real estate practice and I work with many of our clients on co-ownership arrangements. So today's presentation is going to focus on many of the major legal considerations relating to small residential co-ownerships. Before we dive in, I wanted to remind everyone that Eiler Campbell's providing free legal webinars every Wednesday during September. There's 3 more this month, so if you're interested in any of the topics, feel free to sign up for them, but if you can't make it, the recordings of the sessions will be available for free on our blog afterwards. So this is a brief overview of what I'll cover during today's presentation. As I mentioned earlier, I'm going to talk about some of the major legal considerations around co-buying and entering into co-ownership arrangements. This presentation will be a bit more relevant for smaller residential co-ownerships, which is what we see more of, but it will also be applicable to co-ownerships with a larger number of people. So co-owners face many of the same issues that regular home buyers face when it comes to actually completing the purchase of the property, but there's of course an added dimension that comes with having a group of people own the property. So I'm going to start about addressing what a co-ownership is in general terms and why people are turning to this option. I'll talk about the legal relationship between co-owners, some of the pre-purchase discussions that co-buyers should have before they enter into an agreement to purchase a property. And then the rest of the presentation will address the key issues that should be reflected in a co-ownership agreement and some discussion on mortgages. We'll have some time for questions at the end of the session. So if you have questions, leave them in the Q&A box. We'll also check the chat. Okay, and before I dive in, I wanted to mention that the presentation is going to give legal information about co-ownership agreements, but I won't be giving any legal advice. So please keep that in mind when asking your questions, because I won't be able to, say, recommend something for a particular situation. So if you think you need legal advice on a co-ownership, my email's at the very beginning of this presentation. You can email us and we can give advice after needed. Okay. So what's a co-ownership and why do people co-own? In general terms, a co-ownership is shared ownership of a property by multiple individuals. Ownership can be direct or through a corporation, which I'll address on the next slide. I also wanted to mention I'm going to use the terms co-buyer and co-owner interchangeably throughout the presentation. They essentially mean the same thing, so I'll just use both terms throughout this. Most people are turning to this model because co-owning can make increasingly unaffordable real estate markets like Toronto attainable. Co-owners often pool their resources, which allows for a higher down payment, and leveraging multiple incomes can help owners qualify for a larger mortgage and therefore be in a position to afford a more expensive property. Beyond the financial considerations, many people are attracted to the co-ownership model because it involves a sense of community, some shared living, as well as shared financial responsibilities around keeping up a property. The legal relationship between co-owners can take a few different forms. If co-buyers decide to own the property personally, which is most often the case in smaller residential properties, co-buyers can purchase either as tenants in common or joint tenants. The critical distinction between the two is that joint tenancy includes a right of survivorship. This means that on the death of one of the co-owners, ownership of the property passes in equal shares to the surviving co-owners. For example, it's very common for spouses to hold a property together as joint tenants. Co-owning a property as tenants in common, on the other hand, doesn't carry with it a right of survivorship. If a person dies and they co-owned a property as a tenant in common with other co-owners, the property doesn't automatically pass to the remaining co-owners. Instead, it's dealt with through the deceased's estate. It's possible to create a corporation and have the corporation be the legal owner of a property. There can be tax-related reasons to use a corporation, or there can be other reasons. When a corporation owns the land, this can be either a business corporation or a cooperative. The co-owners typically purchase shares in the corporation, which gives them the right to occupy the property and recover their investment if the property is sold. This type of arrangement can be a bit more complicated to set up, and there are ongoing administrative responsibilities with having a corporation own the property. So if there's usually extra considerations to be taken in mind if that's the way you're thinking of going. Before taking the more formal legal steps to establish a co-ownership arrangement, I always suggest that clients thinking of co-buying sit down and have an honest conversation with each other to ensure you're on the same page. What comes out of these discussions can then be formalized into a co-ownership agreement. And part of the early discussions should involve some financial disclosure to each other, because all of this financial information will eventually come out when you apply for a mortgage. It's also a good idea to contact a mortgage agent that's experienced with co-buying fairly early on in the process and create a budget. Beyond the financial issues, every group considering co-buying should consider their expectations for the property, how finances will be managed, what everyone expects in terms of the degree of co-living, because some people may only want their own units and may not want shared spaces, and other people may be interested in shared kitchens and other areas that will be shared between the co-owners. It's also important to address early on what everyone's expectations will be if someone wants to leave the group. Many of these discussions can happen before you even start looking for a property, but finalizing the conversation will happen when the group zeroes in on a property. And some questions can only be answered when you're looking at a particular property. For example, how a space will be divided between each of the co-owners and each person's proportionate share of ownership in the property. Now we're going to start looking at the co-ownership agreement. And this is where you formalize those pre-contract discussions. And the co-ownership agreement essentially outlines the rights and responsibilities each co-owner has with respect to the property. There's really no one-size-fits-all co-ownership agreement, and it should always be tailored to the particularities of the parties and the property. You can also consider adopting a mission statement that talks about the goals of the co-ownership. In terms of timing, I always recommend that clients finalize their co-ownership at the time they close on the purchase of a property. It's possible to do a co-ownership agreement after you've purchased a property, but just from experience, I find that some clients lose momentum after completing a purchase because they're exhausted and they've spent so much time and money that they just don't want to do another thing. But then if a problem arises or there's a disagreement about how costs are being apportioned between the co-owners, there isn't a guide for how to address these situations, and that can create a lot of headache for people. So I do suggest that people try and finalize the co-ownership agreement at the time you close on a property. So now we're going to go into some of the critical issues that I recommend incorporating into a co-ownership agreement. I won't be going over every single issue that can be addressed, and there may be issues that are unique to a particular co-ownership, such as zoning or redevelopment, but I'm going to go over some of the key issues. Each co-ownership agreement should address the share of the property that each co-owner owns. This is called the proportionate share. Some co-buyers may want to share the property 50-50. Others might want a different split that reflects financial contribution or the portion of the property that's being occupied. The proportionate share can then inform how much each party contributes to certain costs relating to the property, such as repairs, how much you'll contribute towards maintenance, and how much each party will have access to, and the return on investment. Now into mortgages. So the single most important issue for co-buyers to know about mortgages is that responsibility for the mortgage is joint and several. So say you have a group of 3 co-owners, each is responsible for paying 1/3 of the monthly mortgage payments. If one of the co-owners defaults and stops making their monthly mortgage payments, the bank can treat that as a default of all the co-owners together. The lenders don't particularly care about the individual relationship between the co-owners, so each co-owner is severally responsible for the whole mortgage. And if there's a default, a bank's remedy, among other things, is to retake possession of the home. So, but the reality is that many co-owners divide up their responsibility for monthly mortgage payments according to their proportionate share of ownership of the property. And this division of responsibility should be reflected in the co-ownership agreement. To help minimize the risk of a potential default, or if someone is in trouble, co-owners can protect themselves by maintaining a reserve fund that has at least 3 months worth of mortgage payments that can be applied if something goes wrong. And there can also be a process spelled out in the co-ownership agreement that allows for enforcement steps to be taken by the non-defaulting co-owners in the case of a co-owner's default. And this can, for example, allow a defaulting owner to correct a default within a certain period of time, failing which the non-defaulting parties have the right to deal with the property, for example, selling the defaulting party's share in the property. Like any homeowner in co-buying, it's important to consider the day-to-day operating expenses and how they're going to be divided. This includes insurance, taxes, hydro, internet, and money for wear and tear repairs. Your co-ownership agreement should address how operating costs are apportioned between co-owners, and this can be done by proportionate share, by use of the space, or by dividing certain costs between different parties. It can be helpful to set up a joint account where parties contribute certain amounts each month based on an anticipated budget for the year. And you can set up signing authority on the account so multiple parties have to sign off before funds are released. In addition to operating expenses, there can be capital expenses relating to a property. The acquisition costs is part of the capital investment, and many co-buyers contribute different amounts to the down payment based on the share that they're going to own. Capital expenses are different from day-to-day maintenance because they're improvements or changes that give a lasting benefit or affect the property as a whole. These can be things such as roof repairs or, say, adding another unit to the property. A co-ownership should spell out how decision-making around major repairs will happen, and as well as who will contribute and how much. Also, if someone is contributing a particular skill or labor to the property instead of making a financial contribution, co-owners should decide how to value that contribution in financial terms. Depending on the setup for the property, you might want to identify sections of a home that can only be used by certain parties, so they're exclusive use spaces, and common areas. I know some co-ownership arrangements where the only exclusive use spaces are the bedrooms and everything else in the property is shared between the co-owners. So there's a shared living room and a shared kitchen and a shared bathrooms. On the other hand, you might have a house that is divided up into units. So those particular units become the exclusive use spaces of particular parties. And in that situation, maybe only the porch and the lawn are shared, are common spaces. If you're going to have common spaces, it's a good idea to have general rules that govern how these spaces are used. So, for example, rules around noise and responsibilities for upkeep. Relatedly, the co-ownership agreement should address rules around renting, because this can be a point of contention if it isn't addressed early on. Part of the earlier discussions, co-owners should address how people feel about co-owners renting either on a short-term or long-term basis. Do co-owners need to approve tenants, or is the intention that everyone can rent to whomever they want? This can really affect the dynamic of a property as a whole, so it's something important to include. Another important item is the indemnity clause. An indemnity clause basically says that if you screw up and something ends up causing me damage, then you'll reimburse me for that damage. Co-owners will want this type of clause in a co-ownership agreement to protect themselves from things that are outside their control. For example, a co-owner in another unit turns off the heat during the winter to save money while they're away, and the pipes freeze and cause damage to the rest of the property. An indemnity would help protect the remaining co-owners from the cost of that damage, and essentially put the burden of repairs on the co-owner who might have been negligent. A co-ownership agreement should also address dispute resolution, and there should be a fairly clear process for resolving conflicts, because if there is a conflict, you don't want to be in a disagreement about how to solve the conflict before you try and actually solve it. A good dispute resolution clause should be enforceable. It should provide a very clear mechanism to follow in the case of a dispute, and we usually recommend including an external mediator in advance of, say, going to arbitration or court. And this is the last slide. So every co-ownership agreement should have an exit strategy. This is basically a process for how co-owners will respond if someone wants to move out or sell their share of the property. So the arrangement might come to an end. Some co-ownership agreements have limited terms, or some of them are for extended terms. It's good to build in some flexibility that allows one of the parties to leave, because life happens and someone may need to sell at some point. The exit strategy should set out a process for how a co-ownership is dealt with if, say, someone wants to move out or someone wants to sell their share. Usually the process is initiated by one owner notifying everyone else of their intentions, and often there's an opportunity for the remaining parties to, if the departing owner wants to sell, for the remaining owners to buy that person's share at fair market value. If that doesn't work, there's other mechanisms such as selling to a third party subject to approval from everyone else, or leasing back to the remaining co-owners. It's useful for the exit strategy to also address how the property will be valued. So it should involve an appraisal process and address how costs of the sale will be apportioned, especially if multiple co-owners are selling at the same time. And so that's the end of the presentation. I'll now go on to answer some questions. Fraser, I can't seem to open the Q&A box. Would you be able to read?
I can read the questions out.
Okay, that would be great.
Catherine asks, approximately what is the cost of getting a co-ownership agreement drafted?
It really depends on the arrangement you're looking for. I'd say maybe like a very simple one with not a lot of parties, where you don't have a complicated financial arrangement between you. You might be looking at maybe $2,500 as just a ballpark figure, but like I said, there's no one size fits all arrangement, and you really want to tailor this to your particular situation. So if the property is a little bit more complicated, you have there are a number of parties involved, it could be more expensive if it's more complicated, but just as a ballpark, maybe around 2,500.
Another question from Catherine. If a married couple already owns a property and they wish to begin sharing it with another family, what is the process for converting the property into a co-owned arrangement?
So that's a legal advice situation. If that's the situation you're thinking of, then I'd really suggest getting legal advice. It's not something I'd be able to answer here, because there are many factors involved in answering that. So feel free to email us after. But yeah, I think you should get legal advice on that.
And Susan asks, can you go over the two types of ownership? There was proportional and another, I didn't catch it.
Oh, sure. I will go back. So I think this is what the question is. So this is about the ways that people can own property personally. So the first two are the two different types of capacities in which people can hold property. One is tenant in common and the other is joint tenants. So the main distinction between the two is that when two people hold a piece of property together as joint tenants, it carries with it a right of survivorship. So if one of the co-owners dies, their surviving co-owners automatically assume the deceased's share of the property that was owned. By contrast, owning a property as tenants in common does not carry with it a right of survivorship. If someone dies and they co-owned a property with other people, that person's share in the property is dealt with through their estate. So for example, that person's will might set out to whom that property is to be transferred to.
Thanks, Claudia. Leslie asks if we could talk about divorce and prenuptial agreements.
Yes, your co-ownership agreement should definitely address family law issues, especially if there are spouses involved in the co-ownership agreement. But again, it would involve it would have to be tailored to the particular situation between spouses. So we might have a situation where there are multiple spouses, or maybe some are common law, some are married. So yeah, we'd have to, you would want advice on the different ways of dealing with division of property if spouses co-own and they separate.
Okay, thanks, Claudia. And I think that's it for all the questions. Oh, there's one more question from Catherine. Does the co-ownership agreement transfer to future generations?
So typically, no. A co-ownership agreement is just between the parties the particular parties that sign the agreement. So I don't believe a co-ownership agreement could be passed, like those obligations could be passed on to say the son of a co-owner. You would want succeeding generations, if they're going to assume responsibilities, to become a party to a co-ownership agreement.
Great. I think that's everything for questions. Thank you, everyone, for attending.
Great. Thank you, everyone, and thank you, Fraser.
Okay. Bye now.
Bye.